Welcome back to the Deep Dive. Today, we're switching gears a bit, looking at something huge,
Yeah.
Halloween. It seems like just fun, costumes, candy.
But it's way more than that. We're talking about a massive industry, like over $10 billion a year.
Exactly. And when you have that much money and creativity smashing together, well, intellectual property law is right there in the middle of it all.
Absolutely. It's unavoidable.
So our mission today is to sort of peel back the mask on all that. We want to get to the core of how IP, copyright, trademark affects, well, everything this time of year. Costumes, branding, social media, even those haunted houses people love.
Yeah, and it's a real tightrope walk for businesses and creators.
Mhm.
They want to be innovative, cash in on the season.
But they desperately want to avoid the legal pitfalls. Our sources call them legal scares, which is pretty fitting.
It really is. So we're aiming to help you, the listener, understand those invisible lines you just can't cross.
Okay, great. Let's dive in with the most obvious thing. Costumes. Every year, it's Barbie or Spider-Man or, Wednesday Addams this past year. We know they're protected characters, but how does that IP actually, stick to a costume you're buying off the shelf?
Right. It's rarely just one thing. It's usually layered protection. So you've got the look of the costume itself, the specific design, the unique details, maybe the exact cut.
The visual stuff.
Exactly, the visual stuff. That's typically covered by copyright. It protects the artwork, the creative expression.
Okay.
But then you also have the character's name, maybe a logo, specific symbols associated with them. Think like the Harry Potter lightning scar or just the name Harry Potter. That's trademark.
Ah, okay. So an official costume maker is paying for both. The right to copy the look and use the name.
Precisely. They need licenses for both aspects to sell it legally and use the brand name to attract buyers.
And this is where it gets tricky for people selling costumes without permission.
Oh, definitely. The sources give a really good example. Warner Bros. Owns the Harry Potter trademarks. Now, if you sell just a plain black robe, fine.
Yes. Generic wizard.
Generic wizard, exactly. But the second you list it online as a Harry Potter wizard costume, using that protected name,
Oh.
yeah, without a license, you've stepped over the trademark line.
Mhm.
And you could get a cease and desist letter incredibly quickly.
That sounds like a huge risk, especially for small creators, maybe someone on Etsy. They aren't trying to make millions, just get found.
It is a huge risk, and often an automated one. They might think, okay, my costume looks different enough. Maybe they've cleverly avoided direct copyright infringement on the design.
Yeah.
But if they use the trademark name in the listing, Wednesday Addams-inspired dress or something, just so people can find it, well, that's the tripwire.
How so?
These big e-commerce platforms, they have automated systems scanning for IP infringement. Using those keywords can get your listing pulled or even your whole account suspended almost instantly. It's seen as trying to profit off the brand's recognition.
Wow, okay. So keywords matter a lot.
A lot.
So moving from specific costumes to broader seasonal stuff. Companies love getting spooky with their branding, right? Pumpkin spice everything, haunted logos. What happens there? Is that risky too?
It absolutely can be. Now we're moving more into trademark territory and this key idea, likelihood of confusion. Businesses get playful, change their colors, add cobwebs, use a spooky font.
Yeah, you see it everywhere.
But they have to be careful not to get too close to another existing well-known brand. The main goal of trademark law here is preventing consumer confusion about who is actually offering the product or service.
What about parody? If it's obviously a joke, does that give them cover?
Parody can be a defense, but it's tricky, especially when you're using it for commercial purposes, like selling something. The fundamental issue is protecting the established brand's goodwill.
Goodwill. Can you unpack that a bit? What does that mean legally?
Sure. Goodwill is, it's essentially the reputation, the trust, the expectation of quality that people associate with a brand name or logo. It's intangible value built up over time.
Okay.
So if you see a coffee shop that looks kind of like Starbucks, but it's terrible, you might mistakenly think less of Starbucks, right? Even if they had nothing to do with it. That damages their goodwill. And that's why brands fight so hard against anything that might cause confusion.
Right. Which makes that example from the source, a local bakery calling itself Star Spook Coffee, with similar green colors and font, seem really problematic.
Extremely problematic. Even if it's just for October. When courts look at these cases, they don't just look at the name, they use a whole set of factors.
Like what?
Well, how similar are the marks? Are they selling similar things, like coffee in this case? How sophisticated is the average customer? Would they likely be confused? If that Star Spook place sells coffee and uses that familiar green look, A court might well decide that a reasonable person could think Starbucks is involved somehow. Maybe they endorsed it, or it's a seasonal pop-up.
So the fact that it's temporary and Halloween themed doesn't automatically make it okay if it looks too similar.
Not at all. It's the resemblance, the potential to confuse that matters. The big brand has the right to control its image and protect that goodwill they've built. If your spooky fun dilutes their brand or confuses people, it's likely infringement.
Makes sense. Okay, let's shift dimensions now. Haunted houses. These aren't just costumes or logos. They're like full immersive experiences.
Yeah.
How does IP work there? It feels way more complex.
It is complex. Haunted houses are really interesting IP cases because they bundle together lots of different types of protection. Copyright is huge here. It can cover the design of the sets, the specific props, any scripts or storylines, even original music or sound design created for the house.
Wow. So could even the layout, like the path you walk through the maze, be protected?
In theory, yes, if it's original and documented, fixed in some way. But the bigger issue, practically speaking, is usually about using existing content versus creating something new.
Right. Like Universal's Halloween Horror Nights. They do massive original themes sometimes.
Exactly. They either invest heavily in creating totally original concepts, characters, and stories, or they pay significant money to license famous horror franchises, like The Exorcist or Stranger Things.
And when they license something like The Exorcist, they're getting more than just the name, right?
Oh, much more. They're licensing the right to use the specific look of the characters, the visual style from the film, often the iconic sound effects, maybe even key musical cues from famous scenes.
Ah, okay.
So if some smaller, independent haunted house just decides to recreate, say, a really famous jump scare scene from a hit horror movie using the same setup, maybe even the same sound effect without getting a license,
That's a bad news.
that's serious infringement. Potentially across copyright for the visuals, the audio, maybe even trademark depending on what they use.
Wait, a specific sound effect could be protected IP. That sounds like
Yeah.
it could really stifle creativity.
It can seem that way, but yeah. If that sound effect is part of a copyrighted movie's soundtrack or overall audiovisual work, and you lift it to use in your commercial attraction, your haunted house, that's using copyrighted material without permission.
So the big risk is copying specifics. Movie scenes, sounds, characters.
Exactly. Using identifiable elements from protected works without paying for the license. The whole experience, if based on existing IP, needs to be properly licensed.
Okay, that leads us perfectly into the digital world.
Huh.
Social media, it moves so fast. Brands love getting festive online, right?
Yeah.
Posting memes, GIFs from classic Halloween movies. We mentioned Hocus Pocus earlier. Can a company just post a Hocus Pocus meme on their Instagram to promote, say, a Halloween sale?
The short answer is generally no. And this is a huge blind spot for a lot of marketers. They see something everywhere online and assume it's free game.
But it's not.
Not for commercial use, no. Using copyrighted images, like movie stills or popular GIFs to promote your business, your products, your services, that's almost always copyright infringement. The source is really clear on this. Posting that Hocus Pocus meme or a GIF from The Nightmare Before Christmas as part of your marketing, that's commercial use and likely infringing.
Okay, this brings up fair use. We hear that term a lot. Brands might argue, oh, it's just a meme, it's transformative, it's commentary. Why doesn't that usually work for marketing?
Yeah, fair use gets misunderstood a lot. People think it's like a magic shield. But our source nails it. It's a limited exception. Courts look at 4 main factors for fair use, and the first one is usually the killer for brands, the purpose and character of the use.
Meaning, if the purpose is to sell stuff.
Exactly. If the purpose is commercial promotion, it almost always fails that first factor. Fair use is meant to protect things like criticism, commentary, news reporting, teaching, scholarship. Using a funny movie GIF just to grab attention and drive sales for your unrelated product isn't transforming the original work in a way fair use protects. It's just leveraging someone else's IP for your own commercial gain.
That's a really key point. The use isn't about the meme itself. It's using the meme to make money.
Precisely. It's not commentary on Hocus Pocus. It's using Hocus Pocus to sell widgets. So it's definitely not a safe harbor for typical seasonal marketing campaigns.
So what's the safe advice for marketing teams then?
It's pretty straightforward, actually. Create your own original Halloween graphics. Use royalty-free stock images or video. Or, if you really need something specific, license it properly. Just don't grab popular copyrighted stuff off the internet for your ads. It avoids potentially costly and very public legal fights.
Right. This has been fascinating, really digging into the hidden legal side of Halloween fun. So just to quickly recap the big risk areas we hit. The dual IP in costumes, copyright for the look, trademark for the name, the danger of confusing customers with spooky branding and damaging goodwill, the bundled IP in haunted houses covering sets, sounds, stories, and finally, the copyright traps waiting on social media with memes and GIFs.
Yeah, and it all comes back to that core idea. Halloween is bursting with creative opportunities, which is great, but whether you're, a small artist selling on Etsy, someone starting a local haunted house, or a big corporate marketing department, you absolutely have to understand the IP rules. Knowing where those lines are is the only way to avoid those legal scares that could genuinely ruin your season, or worse, your business.
That's a perfect summary. The value of being informed, especially during this kind of creative frenzy, is just undeniable.
And maybe one last thing to leave you thinking about building on all this. Given how intensely protected everything seems to be now, characters, logos, sounds, you name it, how much harder is it today to create something genuinely new and spooky? An original character, a new tradition? It feels like you almost immediately risk someone saying, hey, that looks like, or that sounds like, just because so much territory is already claimed by existing IP.
It really makes you wonder if the next iconic Halloween monster or character can even emerge anymore without getting tangled in legal battles right from the start. That's definitely something to chew on. Thank you for this deep dive.
My pleasure.
We'll see you next time.